Distinguished guests, ladies and gentlemen, welcome back. I hope you enjoyed your meal and had a great lunchtime. Now, I would like to begin the second session of the 13th Asia-Pacific ADR Conference. The topic for this session is emerging and fast-growing intellectual property and technology-related dispute areas in Asia. And for session 2, Mr. Kevin Kap-Yu Kim, founding partner at Peter & Kim, and Mr. Nicholas Vigand, partner at CMS, will serve as co-moderators. And we are also joined by distinguished speakers as well, including Mr. John Chung, partner at Freshfields, Mr. Niels Eliasson, partner at King & Spalding, and Madam Jin-hee Kim, partner at Chi-Pyong, and Madam Ye-ji Kim, legal counsel at Oracle. And last but not least, Mr. Robert Wachter, partner at Shin & Kim. Once again, I'm very pleased to announce that session 2 will be moderated by Mr. Kevin Kim and Mr. Nicholas Vigand. So without further ado, let me hand over the microphone to our exceptional co-moderators. Ladies and gentlemen, please welcome them with a big round of applause.
Hi, thank you everyone. Good afternoon. I hope you have a nice lunch. It's always challenging to start session after lunch. This session is focusing on technology-related dispute, which is quite fast-growing. In a sense, it's still traditional, but we see that there is more demand in the market that is because such an area always required the time-consuming and capital-intensive investment to develop technology, and that technology is quite sensitive, always confidential, and also that industry requires a speedy and quick dispute resolution, but in many cases also involve different type of dispute in parallel. And also that inevitably requires certain type of protections in the course of the dispute resolution. So we are going to deal with that issue as much as we can. We just thinking about 4 or 5 issues we can discuss in an interactive way. So we didn't prepare any PPT. We didn't actually prepare in advance in a particular format, but we are going to discuss more freely, discuss about the issues. So with that, Nicholas, you want to introduce our panel?
Yeah, thanks very much, Kevin. Welcome everyone, good afternoon. I know it's your favorite session, right after lunch. We have the advantage of being blinded by the lights that keep us awake, but we'll try our best that it's easier for you as well. Thanks for the introduction earlier of the panel. I'll just briefly add a few more words about our distinguished panelists so you know who's sitting in front of you. And I'll start on my very left. We have Ms. Jin-hee Kim. She's the head of the Global Dispute Resolution Practice at Chi-Pyong LLC, which obviously is one of Korea's premier full-service firms. She's also the chair of the firm's Global Practice Group and a California litigator by training, and still appears in federal and state courts in the United States. Prior to joining a law firm, she was head of global disputes at LG Display, and during her time there, she had 2 attorneys sitting here today representing her company on separate occasions. I don't know who that was, but maybe we'll find out later. It wasn't me. To her right is Robert Wachter, who is the co-head of the International Disputes Group at Shin & Kim. He has completed his legal education also in the United States, but has spent the last 20 years, as all of you know, here in Korea, except for 2 years when he was practicing in beautiful Vienna. He is very familiar with both common law and civil law approach. I sympathize with that. He acts both as counsel and arbitrator and has experience under all the major arbitration rules, and of course is also very familiar with what we're talking about today, which is IP and technology disputes, in particular in the pharmaceutical, nuclear, software, and defense sectors. Right next to me is John Chung, a partner at Freshfields and head of the firm's China arbitration practice. He has been involved in a number of significant Korean-related arbitrations, including as well in the life sciences industry and the tech sector. and he serves on the leading arbitrations institution and is the chair of the HKIC's Proceedings Committee. To the right of Kevin is Niels Eliasson. He is a partner at King & Spalding in the Singapore office. Before that, he was in Hong Kong for many, many years. Niels has represented clients in commercial construction and investment treaty disputes in Asia and around the world for more than 20 years, and has acted as arbitrator and counsel in more than 100 cases. And he is consistently ranked as Band 1 in international arbitration in Chambers Global, and is also the vice chair of HKIC. Sorry, it's a lot of panelists. We're almost through. Last but not least, Yeji Kim is a legal counsel at Oracle in Korea, based here in Seoul. Before joining Oracle, she served as in-house counsel at WeMade, a leading online gaming company, where she played a key role in international arbitration cases involving intellectual property infringements, contractual breaches, and other matters. She handled litigation cases related to cryptocurrency, delisting, and blockchain-related issues. Yeji has also contributed to exit cases during her time at the Ministry of Justice. Right, okay, so you have a very esteemed panel in front of you with very diverse backgrounds, but I'd like to start right away with Yeji as our in-house counsel, current in-house counsel, with a prior in-house counsel, but a current in-house counsel, to discuss one of the topics that's at most in-house counsel's heart, I'd say, and that's the time that arbitration takes, the time sensitivity, especially in the cases that we talk about today, IP-related cases. So take the life sciences sector. When you have a drug development process, if your arbitration takes 3 years, it simply might be too late to get your regulatory approval, to get the drug developed, to go to market. Same in your industry, in the tech sector, IP-related issues can block a product from coming to market. And the holiday season is coming. If you can't sell a product, it's quite detrimental. So time sensitivity in these industries is key, and we'd like to kick off the discussion with your views as an in-house counsel at Oracle. How do you perceive we as the arbitration community are dealing with the issues of time sensitivity? Are we doing enough? Can we do better? What's right and what's wrong?
Thank you. Thank you. Well, first of all, when we had a preparatory meeting via Zoom, Kevin told me my role was here to sit here and complain and yell at arbitration lawyers that arbitrations do take long and it's very costly. So my assumption was that all the arbitration lawyers hear that a lot from the clients. So I'm not gonna go there because I want to walk out of this room with my suit intact. This is my only suit because I don't wear them in my workplace. But
I'll protect you.
So personally, I don't believe the perception that international commercial arbitrations are more lengthier than domestic local court proceedings. From my own experience. However, I do also understand the frustration of corporates and company executives because with the two reasons, I think. First of all, is the due process of international commercial arbitrations that do not exist in Korean courts. And second is that because of the tech industry's characteristic, there is a common notion that once you're not it's a zero-sum game, this tech industry. If you're not a front runner or if you're not one of the best, you are not even able to enter this competition. So more and more companies get frustrated if they feel like these court proceedings where a critical asset or critical IP is at stake. I think they fear that they're going to not only lose profit, but they're going to lose the market share, and they're going to lose their name in the competition completely. So in that terms, I've always wanted to hear thoughts and experience of the expert arbitration lawyers. Because I'm sure you all have heard those concerns from your clients, and you have experienced how damages could accumulate to insurmountable level in a short period of time. From my experience, that's the IP. And so I want to, just throw out a question with no responsibility. What kind of process have you thought was effective in this term, in this sense? What process, what specific solutions or methods have you found them effective in not only shortening time sensitivity, but dealing in every stages of client angst and anxiety? So that's my question.
My experience, there is a clause in arbitration agreement that arbitration should be completed and issued a word within 6-month period. That was the contract between two very serious companies. Everybody believes it's impossible, but it's such a big company, maid or lawyers could do that. So maybe I can invite John. Actually, looking at this side, it's like a collection of my opposing counsels. John, why the life science or the technical sectors so time sensitive? In your sense, what could be the solution for that?
Sure, Kevin, and very good afternoon, everyone. It's always good to be back in Korea. Let me touch on, I guess, the two broad themes which have been raised. The first is perhaps Kevin's immediate question: why are disputes of this nature so time sensitive? And by this nature, I mean both in the tax sector, and I think in the introduction we talked about life sciences disputes. I think the underlying theme is quite similar. So why are they so time sensitive? And then, to ensure that I don't get yelled at either, perhaps we'll focus a bit more time on what are the potential solutions. And of course, Kevin kind of threw down the gauntlet there with his 6 months example. But let me start with the first of the two topics, which is why are life sciences disputes and indeed tech disputes so time sensitive? I suggest 3 quick reasons for that. First is in the life sciences space, there is a real first mover advantage there, as we know. So you want to be first to have your product out on the market, you have greater pricing power, you have greater brand awareness, you have more market share if you get your product out more quickly. And that's certainly the case, perhaps even more so in the tech sector. At the same time, it's not unusual for there to be competing products which tend to come out at around the same time. I think COVID vaccines are a very good topical example. So again, you want to get your product out there. You don't want to be bogged down by a long, lengthy arbitration. So that's the first reason. A second reason is that excuse me, in this space, intellectual property rights can become obsolete relatively quickly. So you have a relatively short period of time to, as it were, exploit the huge amount of R&D that you poured into developing all these products. And you want to make sure you maximize the time period. You don't want to be, again, stuck in a 2-3 year arbitration where you cannot have first mover advantage and exploit the benefit of all the R&D that's gone into the product. So if you're a blockbuster drug, you want to be out there, you want to have established your brand name there, and you certainly want to do so before you hit the patent cliff and all the generics start coming into play. And a third quick reason is, of course, lengthy disputes just generate a great deal of uncertainty. So for example, if you are developing a product, suppliers who are producing the active ingredients, they may not be prepared to produce the product, to ramp up supplies in sufficient volumes if they think that the product is not going to take off or that an injunction is out there or will be issued that prevents the sale of the product. So again, uncertainty is bad for business. So that's a quick canter through 3 reasons why, and there's certainly a couple of others, why life sciences disputes are so time sensitive. But coming perhaps to the more immediate pressing question that we've been posed here on the panel. So how do we actually fix this? What are the solutions? How do we make the process more effective? I think the answer very much lies in horses for courses. So it very much depends on the tailored approach for each type of dispute. And let me quickly walk through 5 techniques that can be used, and I'm sure others on the panel will comment on that. The first of these techniques for trying to move the process along more quickly is, of course, emergency arbitration. We've all heard of that. We've seen that. Typically, the process takes about 15 days from inception of the application until you receive the decision. And that is where you will obtain urgent interim relief before the tribunal is even constituted. Now, life sciences disputes, why do they matter? Fairly obvious. There's real value in obtaining an interim injunction in some cases, for example, to avoid a party selling a product on the market that will dilute your branding, or where you want to preserve the status quo, you want to protect the real value in your biotech innovation. So I think it's fairly clear that emergency arbitration proceedings can be helpful, can be effective, but the obvious trade-off is that it's really only interim in nature and only useful for relatively more straightforward dispute. If the dispute subject matter involves a great deal of factual content, you need fact witnesses, that probably isn't suitable. Move on to a second example, interim relief. So this is from the tribunal or potentially from the courts. Similar in concept to emergency arbitration, but you generally have a bit more time to put in your evidence and to put in your submissions. And again, in the context of life sciences dispute, it might be useful, for example, if you need, say, an interim specific performance order of sorts, a mandatory injunction to, for example, compel an upstream pharma company to produce the active ingredients that you need to make your blockbuster drug while the underlying arbitration is proceeding. So that's where you get a kind of interim order to compel production of, in my example, active ingredients. Again, interim relief is useful, but it is ultimately interim in nature. So let's then move on to some potentially binding options, and I'll just briefly mention three, because I'm sure others on the panel will want to weigh in on this too. Expedited arbitration proceedings. That's an example which, Kevin, you alluded to of sorts. And this would be a situation where, for example, as we know, in many of the expedited procedures that exist in the arbitration rules, there is a fairly fixed timeline on which the decision or award has to be made. Quite often 6 months is the time period you see. And what the expedited procedure allows is for the arbitration to move along more quickly by typically dispensing with certain steps in the procedure. Now, expedited procedures have the time and place, but typically you hear that the challenge there is they tend to be more useful for lower value disputes. So really not that useful where you have a complex dispute with, for example, discovery or disclosure being required or complex cross-examination. But expedited procedures, that's one option. Let me move on to the fourth of the 5 options. That's around expert determination. So let's move away from arbitration. We are seeing in the life sciences space a greater willingness to consider expert determination. As we know, that differs from arbitration because you're not running a full arbitration process. Rather, you have an expert who will give you his or her views, who's familiar with the subject matter, who will run the proceedings not quite along arbitration lines, not with the full range of safeguards, but at the same time it means that the process moves along more quickly. Now, expert determination is certainly worthy of consideration. By my experience, it is more useful where you have a narrower dispute, which is primarily around the area of expertise of the expert. So if it is, for example, a scientific issue, or your classic example is if it's around valuation of future royalty payments, that's where expert determination has a role. I think it is much less effective if it is a complex factual dispute or legal dispute. But again, in my experience, expert determination can be useful if you can use it in conjunction with arbitration so that certain issues can be resolved through expert determination, while other issues are resolved through the arbitration proper. So that's the fourth of my 5, as it were, techniques or suggestions. And let me come on to a fifth one, perhaps borrowing from, as it were, the construction docket here. And that is potentially the use of dispute resolution boards in the context of life sciences or indeed tech disputes. As we know, where you have a DRB, you typically have certain designated experts who are on standby throughout the duration of the contract. And the DRB members are typically kept updated periodically on what is happening in the underlying project or underlying contract. Now, the benefit of having a DRB in place is that if a dispute arises, you can quickly run off to the standing dispute resolution board members and ask them for a relatively quick decision. So you have speed and you have expertise in play. You have speed because the members are generally broadly kept up to speed on what is happening with the contract, and over time, as more and more matters are referred to them, they're able to respond quite quickly because they'll be familiar with the underlying situation. You have expertise, obviously, because you'll be appointing experts in this field to sit on the DRB. Now, the DRB is certainly an option that is under consideration and being used more in life sciences and tech disputes. Again, going back to my original theme, I think it is horses for courses. So there are situations where DRB is suitable, where, for example, you envisage that there'll be a lot of recurring questions or issues that come up in a problematic contract or project. I think they're less useful, again, where you have a complex dispute, where you might need the expertise and the more cumbersome, lengthier process that you have in a full-blown arbitration. So that's a quick canter through 5 options, and I'm sure others will have views around this.
Thanks very much, John. I think that last point of the DRBs is a very interesting one. I won't claim ownership for it. It's been discussed so many times in the immediate past. I've just spoken on a very similar panel at the ICC conference in New York, and it was the main topic of discussion whether we could, in life sciences disputes in particular, use DRBs to, even when they're complex. So I would disagree on that point, even if it's a complex dispute, but the development of the drug or whatever it is likely still ongoing. So at least you won't stop that by having to wait for the outcome of an arbitration. But perhaps you could move on by getting an interim decision from a DRB in between. So I think it's a really interesting thought to look to the construction industry and lend some ideas for these long-term contracts that we see in the life sciences industry. I know, Niels, you're also very experienced in the life sciences industry, or as well as in the construction industry. What do you think about these ideas of alternative solutions to addressing time sensitivity?
I think the DRB sort of idea, a tailored DRB, is a good idea where you have an ongoing cooperation or a technology joint venture, for instance, between the parties, and you might need to resolve issues as that cooperation goes along. So it's as John said, it's horses for courses. It depends on the situation very much. In addition to that, I only had 3 quick observations that came to mind when hearing the questions posed initially, and also John's alternatives. One is that it's often too late when you have the dispute, right? So you have to think front. There's a front-loading aspect of this, and really making use of the inherent flexibility of arbitration already when you are drafting the dispute resolution clause in other ways, in addition to a dispute board, and what you want to do in terms of ensuring a fast resolution of the dispute. You can do various things tailoring your arbitration clause. The second aspect is to ensure that you have arbitrators that understands IP and technology disputes, because they will more understand the need for speed and the issues that arises, and when speed is needed and when speed is not needed. And particular institutions have rosters for IP arbitrators, specialized rosters for IP arbitrators. So it might make sense to choose one of those institutions in your arbitration clause. The third quick observation is one on court order interim measures that John covered as well, and an additional reason for the obvious one of securing interim protection is that quite often, if you do succeed on an application for an interlocutory application, that can actually be used to pave the way for a settlement. Because if you are in a very fast-moving industry where a patent, for instance, might be obsolete by the time the underlying dispute is resolved, getting that injunction will make or break the entire dispute. So that's another reason to fully explore all the possibilities of injunctive relief on an interim basis.
Okay. Our session itself is quite time sensitive. Maybe we can move on to the second topic, which is specific performance. In the civil law countries, specific performance is like default relief in many, particularly court proceedings. But in international arbitration, we always question whether specific performance is available and how. So whether that would be is it desirable, have a specific performance, and when the specific performance is ordered, could it be have the penalty or any ways to enforce it? So let me start with Jinhee. Based upon your experience, how specific performance work?
How does it work, and how does it tie into time sensitivity that we were just talking about? This is a U.S. litigation case, so I can reveal the parties and the case, the merits. We currently still represent a Korean listed company, Kukbo, in a lawsuit filed by Red Hill Biopharma. It's an Israeli pharmaceutical company in New York State. Let me just give you the timeline here and look at how quickly it really moved on. The contract this was during the COVID time, and the pharmaceutical company was developing a drug named Opaganib for COVID treatment for intense patients, which was quite rare. Kukbo contracted to get the supply of Opaganib. The contract was entered into, I believe it was in November of 2021. A lawsuit was filed in September 2022. During that period, when parties were trying to resolve a dispute, they were discussing, they were trying to negotiate, and yet a lawsuit was filed. Time sensitivity, I think it applies both to arbitration and litigation. But I think if we were allowed to think about what John just mentioned about interim specific performance, I think the parties would have avoided a dispute that is now lingering on, although that Opaganib, the drug, wasn't approved. Now, our client didn't know that it wasn't being approved throughout the world. So the lack of information, the imbalance of information is what prevented the parties from discovering new ways to resolve a problem. Had this case been thrown into arbitration, I think it would have been taken longer. But the court system didn't work either. So in this regard, so I'm going to go back to specific performance. Why do we not seek it? As Kevin just mentioned, traditionally, the common law system were divided into courts of equity and courts of law. In the courts of law, you could only seek monetary damages, and courts of equity, you would only seek specific performance. So I think the common law tradition of dividing what type of relief you can seek before a different type of court, a different type of tribunal, is kind of generated this practice of not seeking specific performance. But nowadays, when we file a request for arbitration, orders of arbitration, we seek everything. We seek declaratory relief, we seek specific performance, we seek damages. So I don't think that we are prevented or we're not doing it. The question is, can we get it speedily enough to get resolution for the parties who want to take control over their matters? So you don't want to let the lawyers or the arbitrators decide their case. They're happier when they actually do the decision-making themselves, right, Yeji? So I think in this case, in this particular case, the parties would have found ways to resolve their dispute had the tribunal or the court ordered the pharmaceutical company to disclose whether the approval process is going positively or negatively. Lack of that information, our client breached the contract of not paying the amount due, and lack of information, they were thrown into litigation that they really didn't anticipate being into, and COVID is now over. Well, it's not over, but the pandemic is over. So the time sensitive, it really does matter for especially biopharma and latest technology cases. So I don't know if that answers. The risk of not seeking specific performance, the benefits of speaking, you're staring at me, I'm going too far, right? I can stop right now.
Thanks very much. Robert, I know you've also had a case where a specific performance was sought but posed some problems. Maybe you can tell us about that.
Yeah, I think the question of specific performance really depends on what cards you're dealt in the contract. Right, if you're going to go and ask for specific performance, you can only really do that for a very specific contractual obligation. And I think that in Korea, Koreans are a very optimistic people by nature. And when they draft contracts that require a lot of cooperation, have a real expectation that the parties will eventually work things out in good faith. And you don't need to put all of your obligations into the contract because that's just something that will be worked out between the parties over the course of performing the contract. And of course, when these cooperations break down, I think it's very difficult to think about seeking specific performance, because if you go back and look at the contract is not specific enough, because the parties were expecting that they would just be able to agree at a future point in time. So the case that I was going to mention, we didn't actually, it wasn't a case where either party sought specific performance. And again, it was precisely because it was a joint venture where both sides at the very beginning were optimistic, but over the course of performing the contract, it just didn't work out. There was a joint venture that included a technology transfer, and it was expected that both of the parties would agree on these projects in the future and eventually form a joint venture company. After the technology transfer, there was a breakdown in the relationship. They never formed the joint venture company. And so one of the parties eventually terminated, and in the arbitration, the tribunal said you had valid grounds to terminate because the other party breached. But as a practical matter, because both sides had a veto right and were not obligated to do specific things under the contract unless they agreed in the future, we can't really determine that there are any damages here. And I think that the same thing comes up for specific performance, where you can say the plan all along was that we were going to cooperate and get along and we would come to an agreement. But if the cooperation breaks down and you don't have anything specific in the contract, then as a practical matter, I don't think that it's going to be feasible to seek specific performance in a lot of these contracts.
Maybe at this time, let me invite Yeji again. Yeah, we talk about specific performance. Do you have any particular question or you want to raise?
Well, I do have a specific question. So my question is revolves around enforceability of those specific performances, because my observation is that in tech industries, I'm sure this is applicable to other industries as well, but for tech industries, it's more of becoming, all the competitors are becoming partners because they are now virtually in an assembly line, assembling their technologies and softwares for a certain service. So for like Microsoft, Oracle, AWS, they are all competitors in one market, but they're also cooperating and collaborating to provide certain service. And it is mostly within these partners that disputes arise. And because their ties are long-term, and because so much are at stake, I think it's, from the corporate perspective, it feels like it's a difficult decision to make when you want to arbitrate or litigate just solely for the damages that you may or may not retrieve. So I think in case where I was involved in, where I met Robert and Kevin as opposing counsels, I was in a claimant side, and claimant and respondents were co-owners of an IP, huge gaming IP, and in the midst of the arbitration proceeding ongoing, they were still collaborating. They were necessitated and obligated to cooperate with good faith to run their businesses. So meanwhile, it was very difficult for me and for the business decision makers to actually make an amicable conversation. So I think my view is that it might have been different if we knew of the specific performance option. It's always good to have a third option for corporate side of view. But always the problem is, can we enforce it? And I want to know, hear your views if you have experience in enforcing them.
Yes, please.
I don't have experience enforcing them, but Yeji, you just asked a question that I was stopped short of saying, which is what I did a little bit of research, and I stand to be corrected because this is research of across the board of several countries about enforcing specific performance when the arbitral tribunal awards it. In South Korea, it's not unlawful, but the award must be specific enough to be executed by a Korean court, the execution officer. In China, there's no hierarchical preference between damages and specific performance. Granted, it's only granted at the court's discretion. In France, parties are entitled to request specific performance unless it is impossible. Damages may be claimed in addition to other applicable remedies sought. Now, Singapore, only granted at the court's discretion where damages are deemed to be inadequate remedy. South Africa says primary remedy available for breach of contract is specific performance granted at the court's discretion. Now, UK is similar to Singapore, only granted at the court's discretion where damages are deemed to be inadequate remedy, and something similar in the USA. I stand to be corrected. It's not a research done by AI, but it gives me a lot of discomfort in recommending client to just seek specific performance because your award may not be enforceable everywhere.
Yeah, but when you see the other possibility, for example, emergency arbitrator, action order, or interim measures, I have experience act as emergency arbitrator, have injunction order in 150 different jurisdictions. That injunction order is effective immediately, and at least in theory, 150 different jurisdictions. Otherwise, you have to go to the court at 150 different countries and make application. Then you're faced with that whether such is available or not. So arbitration, emergency arbitrator or the interim measures by tribunal members, once this order is made, then you have pressure from the tribunal to respect so as far as I understand, the arbitrary institutions have good statistics that the parties voluntarily perform the emergency arbitrator's orders or the interim measures. But it's always a difficult question because when you really try to enforce it in particular jurisdiction, particularly difficult jurisdiction, it's quite difficult to enforce it. And if you want to, get the specific performance order in the main arbitration, it's also challenging. Anybody have a good idea about it or suggestions?
Not really a good idea, but just to tie back to Robert's point that also when it comes to the enforcement stage, the contract provides you with your cards, right? If you have a very wishy-washy obligation under the contract, and even if you convince the tribunal to order specific performance of that obligation, how is an enforcement court going to assess whether or not the party as ordered has cooperated in good faith? Whereas if you have very specific obligations, it's easier to seek specific performance and get those enforced as well. So it's, again, Robert's point about the contract giving you the cards.
I agree with that, and perhaps just to add a couple of points. So I think in terms of enforcement of the specific performance order and indeed obtaining it from a tribunal, a lot depends on how specific the contract is and how easy it is to police the order in question. So I have had experience where, for example, is an order to compel a party to execute a certain contract. That's been relatively easy. And indeed, if the party refuses to, then you run off to the local courts and you get, for example, a court registrar to stand in and execute, in this case, share transfer forms. That's relatively easier. In the tax space, for example, if it's an order to compel a party to produce a certain component, a fairly standard component that you need as part of the supply chain, and that component is easily definable and tested, then again, that's an easier order to enforce. Whereas if it's an order that's more discretionary in nature, then of course that's where you run into difficulty in obtaining such an order from the tribunal. Then coming back to Kevin's earlier point, I think when it comes to interim orders, there is a distinction between interim orders and final orders of final relief. If it's an interim order, such as an emergency arbitration order, as we know, that is difficult to enforce on a cross-border basis. There are a number of jurisdictions in Asia, Hong Kong, Singapore, for example, which do allow you expressly by legislation to enforce an emergency arbitration decision, but in most places in the world, there's a big question mark over that. But that's for interim orders. When we then talk about final specific performance relief, for example, I think that's easier in the sense that in theory you could try to do it and you can be successful in a number of jurisdictions relying on the New York Convention.
Thanks very much. Again, in the interest of time sensitivity, and we'll move on to another topic which is also highly pertinent in IP-related arbitrations, and that is confidentiality of information, or even dealing with classified information. When you think about, for instance, the defense sector, where also a lot of IP-related disputes can take place, you may have one side of the hearing room being able to access documents because they're from a certain nationality, and the other side can't because the documents are classified, which of course leads to numerous problems in terms of due process and equal and fair treatment of the parties. Likewise, in the tech sector, an R&D project which is highly sensitive, only certain people in the room may have had access to certain information that might be highly relevant to the outcome of the dispute. Perhaps not even the tribunal members, or not all of them, are able to look at certain documents in these highly confidential cases. So there's a whole litany of problems that come along with restricting access to documents, to information, to certain members of a dispute, whereas others have access to that. And I'd like to come back to John, perhaps to lay out the ground here of how we can deal with this. How is the arbitration community tackle this, and is there a solution?
No easy answers there. Let me perhaps just suggest talk about two potential solutions. There's a whole range of available solutions. But I think fundamentally the challenge, I think, Nicholas, you've outlined it's I think an imbalance in terms of ability to access the information or documents. That is at the heart of the problem. So in other words, a situation where one side has access to the documents, sometimes it's inherent in the nature of a tech or life science dispute that only one side will have the relevant, highly technically confidential information. And that side which has it says this information is it's a trade secret, there's a great deal of commercial value in it, we can't disclose it to the other side, because once the other side reads it, they get it into the head, they've got the know-how, and they can't unlearn what they have, and that would destroy the value in the trade secret, for example. So that's the fundamental issue, this imbalance in access to information. So how do you deal with it? Well, let me briefly mention two situations. I'll start with perhaps an easier one, given that this is directly relevant to Korea, but really I'll spend more time on the second issue. The first one is, of course, I think a number of us in the room will be aware of the concept of national core technology, NCT, in the Korean context, where essentially there are certain industries, such as in the semicon industry or indeed in the display industry, where because of national security and other commercial reasons, certain types of information, certain categories of information are designated as NCT in the Korean context, meaning that parties who, and I'm simplifying this, I'm sure others in the room will correct me, but essentially if you are not a Korean lawyer, for example, with a Korean law firm, you will not have access to that information. So that creates a real issue in the arbitration context where you have an international tribunal, so they may not be able to access the information. The Korean lawyers with Korean firms can access it, but the foreign lawyers will not, and then you have the imbalance which you need to deal with. So that's a challenge which illustrates where you have a situation of one side having more access to the information than the other. But let me move away from that scenario, which is quite Korean specific, other than to mention you can, of course, apply for approvals in the NCT situation, to come on to attorney eyes only protocols, which is a technique that is used quite often. And that is a situation where essentially the parties to the arbitration agree to a protocol which sets out rules for dealing with AEO documents. So that gives both sides the ability to designate highly confidential information as being highly confidential. And then documents which are designated in that way cannot be disclosed to everyone in the arbitration, but only to certain designated individuals, typically the lawyers or the expert witnesses. So does that work? In my experience, there are a couple of challenges with that situation. I think first there is in my experience, really a potential risk of liberal use of the AEO designation, because there's really quite little downside in just stamping away on a lot of documents and marking them as attorney eyes only, meaning that only the lawyers, for example, and the expert witnesses can read and look at these documents produced by the other side. But most importantly, the clients, the fact witnesses cannot look at those documents. So it creates a real issue there. And the second point, and I'll be brief on this, is around clearly due process. So it is fine if the documents in question are going to be looked at by the expert witnesses, and that's all you need. The expert witnesses can look at the documents and explain it, and you can present your case. That is perfectly fine. Where you run into a due process concern is if the fact witnesses, for example, on your side, will be able to shed additional light on these AEO documents, but because of the AEO designation, they are not permitted to look at these highly confidential documents. So they can't review them, they can't give testimony and evidence on those documents. That's where you run into a kind of due process concern. Because again, remember, one side has full access to all these AEO documents because it came from them. The other side doesn't. Only the lawyers and the experts on that side can look at it, but the fact witnesses cannot look at it. And in a situation where the fact witnesses, and I've encountered this, can shed light on these documents because they're familiar with the issues in dispute, but they're not permitted to, they can't look at the documents, then you potentially have a due process concern. There are some solutions to that, but I'll leave it at that.
Yeah, actually, when you're talking about confidentiality, it's not just simple confidentiality, because nowadays I see, as John talked about the national secret issues, then it's really serious. So you shall not make a copy, you shall not use it, and we make a separate transcript for different proceedings. In the course of arbitration proceeding, you stop and just okay, from now on we have different recording, different record, and you cannot copy and carry anything. You have to go there to just see the hard copy only. That is not just simple confidentiality, really challenging things. And then I have some case where 3 different layers of confidentiality: the confidential, highly confidential, highly confidential. So whenever I say, okay, this is highly confidential, most of the people left the room and just only a few people in the hearing room. And then you have a second level confidentiality of the other people coming in and just have a continued. That is quite challenging in actual arbitration proceedings. So Neil, if you have a confidentiality clause in a contract or substantive protection of confidentiality, does it help or is it effective?
No, I mean, before I address that point, it's your last comment, Kevin, is very pertinent. We did a number of years ago a big nuclear-related arbitration where we had exactly that issue with certain part of the information required a defense clearance to have access to. So we had only people on the team who dealt specifically with that claim and related experts and witnesses got clearances, and the arbitrators. And it was when those issues were heard, as you said, people had to leave the room who didn't have the security clearances, and there were also parallel versions of all pleadings that excluded or included information pertaining to this. And we had to set up quite rigorous systems internally, obviously, to comply with the defense regulations. So those are very serious issues. The point on the substantive confidentiality issues I wanted to address is one that when it comes to technology disputes and IP disputes, one can quite often make very effective use substantively of non-disclosure obligations, confidentiality clauses, and obligations not to use confidential information in other ways than authorized under the contract. And it might, because we often see if you have a technology joint venture, a cooperation agreement, a license agreement, there will be a very broad definition of know-how and confidential information, basically all technical information transferred from one party to the other under the contract. And it is and sometimes it is much more effective to commence a claim for breach of such confidentiality / no use clause than to prove a patent infringement or a copyright infringement. So my comment on this type of confidentiality clauses in IP-related agreements is that they can be a very important strategic tool on the substance that one should not overlook in trying to find the easiest and quickest, to get back to that topic, way to an effective result for the client.
Thanks very much, Niels. I think it's interesting that on this topic of confidentiality and how to protect it, I think each one of us can share a very painful story on how this affects and actually disrupts the arbitration. I think you're completely right, Kevin and Niels. I've had a very similar case where doing a hearing is actually quite good for your back, because people were getting up and sitting down, leaving the room, coming back in. It was a lot of motion, but of course it's not good for the proceedings. It creates a great disruption, and it makes it very difficult also to write the award for the tribunal, because you'll have various versions of the award as well with redacted portions, which of course for the assuming the side that doesn't have access to the information loses, will wonder what's in those redacted portions, right? So it creates a whole as I said earlier, litany of problems. There's AEO also is not a really good solution. I've had a case where it also disrupted the proceedings completely, because the parties kept fighting for almost a year about what is AEO and what is not AEO, and it ended up becoming a very costly exercise. So with all that said, Robert, it seems like there's many proposals for solutions. Intermediary agencies can also be third-party advisors, or also proposed confidentiality clubs. All of that is raising a lot of criticism and seems to raise more problems than solutions. So what really works?
I think that the best thing that works is for the parties to reach an agreement, and sometimes under pressure from the tribunal. I think that it's naive for us to think that, well, arbitration is confidential and so we can rely on the rules and nobody has to worry about any of these things. We have common law protections if you are seated in Singapore or Hong Kong. There's a question about that in Korea. So you can't just assume that because the arbitration rules say that you have confidentiality protection, that that's going to address even the simple confidentiality. I think that the rules and the common law rule, it's like a wall of Swiss cheese, full of holes if you really are expecting to protect highly confidential information. So I have been in arbitrations where the tribunal has leaned on the parties to reach an agreement, not only for how information will be treated during the arbitration, but also how it will be treated at the end of the arbitration, including a confidentiality agreement that will call for the destruction or return of confidential information, that will say whether documents can be printed or whether they can be stored in soft copy, and that would require certifications from the parties or counsel at the end of the case that all of this has been destroyed. Therefore, you're not open to concerns about the typical exceptions to confidentiality where if you're ordered by a court to produce it, then that would be an exception, for example. Or there's the common law exception that if it's to advance a legal right or defense, right? If you've destroyed all the documents and you no longer have them in your possession, then that's no longer a concern. But I really think that it's important to reach an agreement, and that can be hard without strong encouragement from the tribunal. Because even if both sides conceptually agree that arbitration should be confidential, by the time you have an actual dispute, that will typically be a more sensitive issue for one of the two parties. And so there might be a shift depending on the facts of the particular case. So I encourage you, reach an agreement, and I encourage tribunals to lean on the parties to reach an agreement.
I would propose, actually, because I see all the representative of arbitrary institutions here, arbitrary institutions really think about some arrangement for protection of a highly confidential information, because it is a really demand market, as Robert explained, that is very strict. You shall not copy. If you copy, you make sure you destroy that. You are not allowed to give any documents to anybody else. It's just you should have the arbitrary institution also have some system, and you shall not use internet when you use that information. You have a separate server, and you have a separate connection to the information. So the institution also have a similar protection or similar arrangement accommodate such a need. So that because it was from the defense industry, pharmaceutical industry, I didn't know that some pharmaceutical thing is really such a confidential things. And also the other nuclear power plants. So many areas we're dealing with have confidential information and protection of confidential information. A lot of restriction on it. So maybe it would be good homework for institutions to think about how you prepare that mission.
Can I just ask one follow-up question, because I don't think nowadays there can be no panel without mentioning of AI. Does the panel think that perhaps AI can help in identifying and blackening out or redacting confidential information, perhaps even summarizing the documents that some people can't see or not allowed to see? Is that something that the panel thinks is a way forward?
Well, I haven't used it or seen it in action, but I can imagine the AI would be very effective for AEO redactions, for example, because that's quite a straightforward process and has been mentioned. You look at all the junior associates having to manage the different sets of pleadings and witness statements is a complete nightmare. So at least in that area, I think AI would be well suited. I think clearly where you need to exercise discretion, I think that's where it's trickier.
Okay, now we move on different issue with parallel proceedings. So in this type of dispute, you easily see there is some other litigation, injunctions, and local code, and criminal investigation, or certain different type of the proceedings going on that have a lot of impacts on the in arbitration. For example, there is some previous litigation done. They have impacts on the. There's a lot of arguments whether they can be used or not. So maybe. May I ask Neil to explain that issue and share your experience?
Thank you, Kevin. One of my pet topics of parallel proceedings. And I think when we use the term parallel proceedings, typically that term in and of itself has a negative connotation, implying something that is vexatious or even abusive. And I think this is therefore important as a starting point to distinguish between different categories of parallel proceedings if we use that broad term. And the first one is, I think, the proceedings for interim relief from state courts that Kevin mentioned. And this is something that I don't see as parallel proceedings in the negative sense of the word. I see it rather as ancillary proceedings or supportive proceedings. And in my view, when it comes to tech disputes and IP disputes in particular, if it was not for the possibility to obtain ex parte interim relief or interlocutory injunctions or other form of court orders depending on the legal system, I don't think arbitration would be an effective means of resolving IP-related disputes at all. Instead, parties would resort to the courts for those disputes if we couldn't go to the state courts for urgent interim relief. And in some instances, emergency arbitrator proceedings can fill that gap, but in many instances in the IP and tech space, parties still require access to robust ex parte relief that can be rolled out simultaneously in a large number of jurisdictions in order to achieve the level of protection required not to erode the value of IP rights and technological innovations while the underlying dispute is resolved in areas where you have very fast-moving technological developments. So when it comes to interim relief from state courts, I really see that the availability of parallel proceedings, if we use that term, or ancillary proceedings, as I prefer to call it, as something that goes really hand in hand with effective legal protection and enhances the legitimacy of the overall dispute resolution system. So I would distinguish that from the next category, where we have parallel disputes on the substance of a dispute on the merits. And this can be, in some instances, legitimate. It can sometimes be abusive. You have to look carefully at that as well. So what we quite often see is that one party files a request for arbitration for breach of a license agreement, for instance, and the responding party immediately files a state court application to invalidate the patent underlying that license agreement. And of course, an application to invalidate a patent can be a very legitimate application to make, but when it is made in an immediate response to a filing of an arbitration for violation of a license agreement, it begs the question whether it was filed solely for the purposes of disrupting the already filed arbitration proceedings. And this is in particular if the seat of arbitration is one that has broad arbitrability provisions when it comes to IP-related disputes. In Hong Kong and Singapore, for instance, it is clear in legislation that the validity as between the parties of a patent is arbitrable. So there is really no need for the respondent in this instance to in parallel go to court to invalidate this patent. They can raise the same objection in the arbitration. So in that instance, in my view, the arbitrators should be slow to suspend proceedings pending the resolution of the patent invalidation proceedings. If the seat of arbitration, on the other hand, is in jurisdiction where it would be unclear whether it is arbitrable, the validity of the patent is arbitrable even between the parties, then of course you have a jurisdictional issue in the arbitration as well, and the issue becomes more complex. The situation can also be the other one, that is the claimant party that duplicates the proceedings. You might have a claimant that files one arbitration for unauthorized use of technical information transferred under a cooperation agreement, that at the same time files a claim for patent infringement relating to exactly the same innovation that both disputes concern, and relating to the same loss and damage. These might be legitimate if the parallel court proceedings is to invalidate a patent that the respondent party has sought, for instance, in violation of existing patents that the claimant party is holding. Then this duplication can be completely justified and necessary. But if it is only to seek the same recovery of damages in multiple fora to put maximum pressure on a financially weaker party and potentially drive that party out of business as part of a litigation strategy, you might have to look at it differently from the arbitrator's perspective, which again goes back to my earlier point that it is very important in these disputes to have arbitrators with sufficient experience in handling IP disputes and choosing the seat of arbitration wisely. Thank you.
Thanks very much, Niels. Robert, you told us about a case where you had true parallel proceedings where the outcome of the one was negating the outcome of the other. Can you enlighten us on that?
Right, and this is really the trade-off that you have to keep in mind if you decide to arbitrate the dispute, right? One of the great benefits of arbitrating is that you stay out of the national courts, but there is a risk that there may be a third party or a regulator that can go to the national court, and the national court will have the final say, and then you might end up re-arbitrating based on the change of circumstances. One case that I was involved in was where we were representing the licensee of intellectual property that was co-owned. And so one of the two co-owners granted a non-exclusive license over the objection of the other co-owner. And so the licensee was in the unenviable position of either being threatened with injunctions or being threatened to be sued if they proceeded to try to develop what they were trying to develop under the license. And so the real issue there, the licensee didn't want to pay the royalties under the license because they're arguing we can't use this, because there's a dispute between the two co-owners. And so there was an arbitration as between the licensee and one of the co-owners that went to completion, but that was the case that finished first. And then there was separate state litigation between the two co-owners that ultimately resulted in the conclusion that the one co-owner violated the law by granting the license without following the required procedures. So now there's yet another arbitration, now that the state court has ruled, that seeks to undo the effect of the original arbitration, because in effect, the argument is that first arbitration is only tentative, because the arbitral tribunal is not in a position to make a final decision with respect to the two co-owners. And this also was trickier because the contract was governed by the laws of country A for exploitation in country B, and it was the country B national courts that ultimately said that this license was granted in violation of law. So it's just something to be aware of. The benefit of arbitration is that you can avoid the national courts and you can do the arbitration in English, and there's a lot of benefits of that. But there is a risk that even if you win the first battle, you might ultimately lose the war.
Let me invite Yeji again. I understand you have some experience dealing with parallel proceedings all around different jurisdictions. Do you have any comments on that, what we discussed now?
Yes. So I think the case Robert referred to was the case I was involved in, and but from the corporate's perspective, I don't know how arbitration lawyers would perceive it as, but from corporate legal's perspective, we thought it could be some sort of strategic leverage that the company could use by using parallel proceedings if the cost is not a problem for that specific company. So for that specific case, the respondent used their winning of the national court case for their good press, and the claimant used their winning of the arbitration and the national court proceedings for the benefit of their press, media press, and so in this regard, I don't know if arbitration lawyers would recommend parallel proceedings. It's now a moral question, I think. But would you? Do you guys have examples or experience using parallel proceedings as a strategic measure to benefit clients? Is that a common practice?
Let me ask Jeannie answer to that question.
I think Yeji's always looking at me and asking questions. My answer is you should always reserve parallel proceedings as a, if not an alternative, an equally important measure. And I have two cases that I can talk about that are ongoing. One is a breach of contract case coupled with trade secret misappropriation. The parties in this case, in the contract they agreed that when it concerns IP or trade secrets or IP or patents, they will have the right to resort to national courts. But all other matters will be decided by arbitration. So in that case, involved both damages of contract and breach of misappropriation of trade secrets. It did benefit my client to have sought parallel proceeding in a court and got the preliminary injunction. Without it, I don't think that it really it goes to the merits of the case, not just tactics. On another case, it's also an ongoing arbitration. We sought interim relief to enjoin a party from doing something before the tribunal. It was a 3-member tribunal. It took more than a month to make that decision. So in the interim, we went into the national court and got an injunction the next day. So the client was extremely benefited by it. So I would never rule out the possibility. So I kind of echo what Neil said. There's a negative connotation to it. But I don't really think that's it. And it doesn't really benefit always to be just before one arbitral tribunal. So I think you don't put your eggs in one basket, leave your options open, but I may be a minority in arbitration practitioners.
Bill, your turns.
I mean, I fully agree with that, which I think was shining through my comments earlier, that you have to make strategic use of parallel proceedings, and in particular, interlocutory injunctive relief can be very effective to shortcut a whole dispute, and also other forms of parallel proceedings when it works for you, and you don't risk alienating, arbitrators and the courts by you appearing to be vexatious and abusive.
Thank you very much. Let's just very briefly touch on the last topic that we wanted to discuss in the context of IP disputes, and that is the use of technical experts. You all know that when IP comes into play, especially in the tech sector, it can become very complicated and very technical and hard for us lawyers or arbitrators to understand. So there's very often, if not always, an expert involved. And I'd again like to first look at our in-house counsel here, and because you're footing the bill in the end, what is your view on the use of technical experts in this type of dispute that we're discussing here today? Is it always necessary? Is it always helpful when sometimes even technical experts are maybe too technical and the tribunal doesn't even understand what they're saying?
Yeah, so I found, first of all, expert witnesses are critical in commercial arbitrations based on my experience, because, and yes, they tend to speak different languages, and that is where I think arbitration lawyers do play a significant role, and like essential role. They basically, I saw that my arbitration lawyers basically interpreting every single terms to the tribunal so that they could understand these intricate or high-level concepts of these newborn technologies that they were never around. So, for example, before about 20 years, there were the gaming, for online gaming company, the main gaming, when you say you're playing game, you had to use a CD-ROM. And then later on, you had to use web games in order to play massive MMORPG games. And then there's HTML games. And then later on, we have mobile games. And now we have blockchain games. So we have evolution of platforms. And there was a case where it was questioned, when we licensed the IP license for PC client games, does that mean we've licensed it so that the licensee could use it for other platforms that were not invented at the time of the execution of the license agreement? So that was a heated debate, and expert witness played a key role in explaining those kind of terms and concepts. So, but I always wonder, as an in-house counsel, and I wanted to, hear your experiences and views on whether you think what good technical experts are, because from corporate side, we want them to be very specific and intricate and very accurate in explaining everything. But what I've observed is that tribunal does not sometimes not that they don't understand, but they don't really accept those views of those experts. So I wanted to ask, what kind of expert witnesses you think it's the best fit for such a huge IP dispute?
Robert, do you want to take this?
Yeah, I have always had a skeptical view of experts in general, and technical experts as well. I do not see an arbitration as an exercise for a tribunal to listen to two experts and to decide which ones seem more credible, which ones seem more persuasive. The role of the tribunal is to figure out what the truth is. And as counsel, when I'm reading both sides' expert reports, I'm not going to stop there and take those at face value. I'm going to try to educate myself. I'm going to try to find what the key authorities are as a cross-check to help me develop better questions for my own expert, to develop better questions for the other side's expert during the cross-examination, and to be in a better position myself to be able to explain things in non-technical terms to the tribunal. I don't know if it's a controversial statement to say that lawyers should do their own research and really try to understand these issues. I have had cases where I think that if you approach it that way, that the role of the experts and even some of the fact witnesses is to help the tribunal understand and decide the case properly, then that opens up a lot of opportunities. I had one case with a Singapore arbitrator where on one side there was an independent expert and on the other side there had been an independent expert who had to drop out, and the party wanted to put forward a party-affiliated so-called expert instead. And this, without hearing what the witness was going to say, the arbitrator expressed severe reservations that one side had an independent expert and the other side did not. But if you look closely at what the person was going to testify, was testifying about the company's products, about the background of the technology, where this didn't really go to the key sensitive difference of opinion. It was really just for background information to help the tribunal understand. So in a case like that, I thought that that was perfectly appropriate. And I think that one of the challenges that we face is that we need to break things down for the tribunal so that they're not trying to both understand background information and technology to get to the point where they even understand what the dispute is, and also to try to decide the dispute in the same hearing. I think that it makes much more sense to have an earlier hearing or some educational system where we can at least go through the technology and what should be common ground so that the arbitrator can get to the point where he or she says, now I understand precisely what the dispute is. Now I can go back and read the reports critically to be more prepared for the final hearing when we'll have the cross-examination and I'll decide one way or the other on the technical issues.
Okay, now we have just 2 minutes. May I invite any questions or comments from the audience? Yes, Grant Kim.
Okay, thanks for the really excellent panel, and despite having so many people, it was a very lively, interactive discussion. I want to go back. John Chung, I think, mentioned the issue that you want to tailor one of the great things about arbitration is you can tailor the procedures to the particular dispute. And then Yeji mentioned, she was concerned about risk, managing risk. So the question I have is whether you have, in my experience, I've had some exposure, I haven't actually used this, but to kind of creative solutions in arbitration to managing risk. And the issue, I think, especially in IP, patent disputes, other IP disputes, can be the stakes are incredibly high. If you're on the defense side, you may end up paying a massive amount of money, or even being worse, being out of the market entirely if there's an injunction. On the claimant side, you may have your valuable IP held to be invalid. So when the stakes are so high, you have no choice really except for to fight like crazy. So the creative solution I've heard of, and I wonder if you have experience with this or perhaps a different creative solution. I heard about it from a life sciences company that licenses a lot of its technology to other companies. And they're okay with licensing, but they want to have what they consider a fair royalty. And if they can't reach an agreement with a particular company, they negotiate a bounded arbitration agreement under which basically the arbitrators will decide that the license fee will be at least a certain number and no more than a certain number. So both sides know that their risk is within a particular range, and there's no risk of the IP being held invalid or there being an injunction.
quick answer? Time is already up.
Sure. And Grant, I suspect that you ask us a difficult question. I agree that that is certainly an option, and more broadly, I think it's related to the concept of midstream conferences that we hear about a lot, right? Where I think the tribunal can come in at some stage in the process, relatively earlier, for example, and with the agreement of the parties, come up with various proposals on how cases are moved forward. So, for example, if there's a particular issue that's in dispute, that's fundamental and core to the dispute, if the parties agree, the tribunal could start giving a preliminary view on those issues, and then that will help it make it easier for the parties to then go away, because often a lot of these disputes that you talk about is ultimately about royalties and renegotiating and leverage to come up with a better price. And then, of course, with the benefit of the guidance, the preliminary guidance that you're getting from the tribunal, and I think the concept of ranges that you talked about, Grant, is similar to that, then the parties can go away and hopefully come up with a mediated outcome. Because as you say, often in these disputes, the two extremes of the potential results are just too, I think it's too high risk on both sides, and that's where there is typically room to find a middle ground. I think parties, as you know, struggle to do that on their own accord. The lawyers don't necessarily assist in that, but that is where, if you have the process akin to a kind of midstream conference, and where there's more willingness to consider other types of guidance from the tribunal, that can actually push the parties towards a certain direction and ultimately resolve it.
I think I might be the last to speak, but I want to throw out just really controversial, provocative idea out there, just so that maybe we can start discussing this. In another word, two words that has negative connotation is piecemeal litigation, right? People don't like it when you just litigate piece by piece. But I think it's time now we think about piecemeal arbitration being not a negative thing, but a positive thing, because it's too risky to bank your case, too important of a case to just one counsel, one tribunal. What if they don't manage the case that they should? Make preliminary determinations as need be. So you as a party may want to structure your agreement to allow your cases to be handled piece by piece, such that you don't spend too much time, money and time upfront deciding really important issues that you can settle with your opposing party.
Thank you very much. That's food for thought for the coffee break and beyond. I think, Grant, what you said is a good summary for this type of dispute that we've been discussing. The stakes are always very high, and we could have gone on for much, much longer. We selected a few topics, but the screen up here started blinking frantically, so I think that's a subtle message that we should stop. Thank you so much to a wonderful panel and my co-moderator, Kevin, of course. Thank you for a very good session, and thank you all for listening and being here right after lunch, and enjoy the coffee break. Thank you very much.
So that brings us to the end of session 2 of the 13th Asia Pacific ADR conference, titled Emerging and Fast-Growing Intellectual Property and Technology-Related Dispute Areas in Asia. We would like to thank our distinguished co-moderators and speakers once again. We will now take a 10-minute break before session 3. Please feel free to enjoy some coffee and refreshment available at the lobby. We hope you enjoy your break.